And now let's go back to our earlier story with the minorities case, and now the president assenting to the E-Levy, which has become law, awaiting gazetting in the next 21 days. Justice Abdulai is a private legal practitioner. He is the one who challenged this particular jurisdiction of Parliament and the issue of quorum at the Supreme Court. That's the case of Justice Abdulai versus the Attorney General. That particular case that the minority is making reference to in their suit. Justice Abdulai, good evening to you.
Good evening, Alfred.
Thank you.
It's been a long time.
It's been a while indeed. But obviously, you have been a reference point for the minority in that particular suit, challenging the issue of the quorum in the decision to pass the E-Levy. First of all, I want to find out from you, now that this bill has been assented to by the president into law, how will that impact on that case in court?
Well, government business continues, notwithstanding the presence or absence of the legal suit. There is no specific injunction application that has been filed by the parties who have presently sued the state over the passage of the law. And so what it means is that until there is a positive order from the Supreme Court ordering the state to hold on, everything continues. And the moment there's a positive order ordering the state to hold on with the implementation, and that would normally be done upon an application having been filed by the minority or Haruna Idrisu and my good friend Samuel Okujuso-Ablakwa.
I see.
Once they make that application, it will be determined on its merit. But usually, even such applications would have difficulties being granted, considering that the state interest usually override private interest of persons. But with this particular case, I think the interest of the nation is also at stake. The majority of the people interests are at stake. And so I'm sure if an application of this nature is brought to injunct the state to hold on with the implementation of the E-Levy, the court may probably look at it more favorably than it would otherwise do with other private cases.
Well, just for the benefit of analysis, okay, for our viewers and all of us who understand this, assuming the Supreme Court rules in favor of the minority, what happens?
Exactly why sometimes the state, in fact, sometimes in such matters, the state doesn't even need to wait for a positive order from the Supreme Court or from a court in order to hold on. Because really, when a court or when a judgment is delivered and that judgment seeks to, and that judgment take away the passage of the law and nullifies the law, literally what it means is that all rights, typically there are two options that come in. All rights that were enjoyed were valid at the time that they were enjoyed by the state. However, there may be consequential orders by the Supreme Court to the effect that all monies that have been collected up to the point of the day of the judgment should be reversed to the persons who were affected thereby. And that usually will bring some level of chaos. And so it is indeed for some of these reasons why it is always better to be a bit circumspect with the implementation of the law, notwithstanding our strong desire for resources for our development.
And without getting into the realms of sub judice, you would have recommended, just for the benefit of analysis, that this legal hurdle be cleared before the president assents to the particular bill into law, and then eventually the application in May.
Usually, even where the president assents to a bill, the implementation dates are not immediate because it has to go through a series of other processes, which would include, among other things, setting down the modalities for the implementation of the act, and those technical issues take a while. In addition, there are also times where the bill, having seen the accepted one act, so I would not be able to say this, but for some time, the act itself would also project into the future that its operation starts from a post-dated period. That's because a lot of things would have to be done administratively and sometimes structurally. So without all these having been done, it becomes difficult or sometimes impossible for the act to be implemented. And that is why few times you see that, or maybe a few times you see that legislations that involve taxes or involve collection of bills, fees and charges, they usually are futuristic in nature because of the structure that would have to be put in place, and sometimes the consultations and education that have to go on before they are implemented.
Lawyer Justice Abdulai, I thank you very much for your time this evening. Appreciate it.
For God and country always.
Appreciate it. Lawyer Justice Abdulai is a private legal practitioner and a lawyer as well who challenged this particular issue of quorum at the Supreme Court.